Hello world, welcome to my channel, Proteus Augustus. I'm an artist, scientist, and American Constitutionist. Today is June 3rd, 2019. In an earlier video, I presented primordial tendency, the third theme of my art project, Objective Observer. In my last video titled Lawyer Wars, I drew a distinction between constructionist and activist lawyers. Also, a few days ago, I read a reply to a comment I made on abortion in life that simply said, quote, source. I construe that to mean the gentleman wanted to know how I formulated my opinion. Also last night, Kristen Gillibrand went on a tirade on Fox News. I saw a clip of on YouTube, lambasting the pro-life people. Her opinion is totally couched in the fact that a woman has the right to determine the size and the type of family that she wants, totally devoid of any male relationship. I find that a bit disturbing. In any event, that's where we are in the world today. So, not only am I going to wrap up primordial tendency in this video, the paper I'm going to read also illustrates what an activist opinion is, and I will give answer to the gentleman who wanted to know what my source was. Now, before I read this paper, it's important to understand that given the limitations on a leaflet such as this, I had to, and not just because of that, my writing style is de minimis when it comes to articles. I try to use more potent words to get my meaning across. So when reading it, it might be a little bit easier to digest, but when listening orally, it may sound a little complicated, but it is what it is. Well, and also, some people after I read this will say, well, there's a lot of your personal opinion in there. How is this a Constitutionist paper? Well, I do give a little bit of an introduction to what life is to me. But seeing how Roe v. Wade is such a weak argument, there's really not a whole lot of legal ease to get into. So, at this point, I would like to read Constitutionist paper number 5, Personhood. I may stop and give a more clarification in areas where my writing is a bit de minimis, and after I read it, I may have a few comments. So let me read this for you. This is the first Constitutionist paper in whole that I've read. Constitutionist paper number 5, Personhood, first edition, number 3 of my Objective Observer. This is the third theme. What does to be alive mean? Is it merely animated organic matter capable of propagation, or must there be a realization of self? Cannot children distinguish between a lifeless mass of earth and ants who colonize it? Is a person alive because she or he thinks? An amoeba dead because it doesn't? Not being able to reject an amoeba's independent manipulation and digestion of matter, its pseudopodal locomotive force aimlessly oozing, nevertheless gaining position in space and time, grappling the scaffold of its medium in a mitotic asexual release, or an ant's march, its antennal conduction of azimuthal guidance, dissemination of duty, doting upon layer and brood, I must conclude life non-animistic. Rather, organic organization interplaying intrasomatically to perform an operative function on its surrounding, primarily for its survival and replication. Orchids beacon to the bees an ultraviolet solicitation for symbiotic woo, and conifers open ovule-bearing ornaments to penetrating polliniferous winds, seeded by heterosexual counterpart, never to ask why, yet they live. So too our gametes live. We impart life force to them. The sperm swim through uterine sea and up fallopian stream akin to salmon run. Ovarian lock releases ovum into fallopian rivulet, descending in its gravimetric flow. Life forces meet. Competing sperm torpedo ovular membrane relentlessly for final penetration till the life force of one breaches its future. Haploid to haploid, fertilization is complete. Is the zygote alive? How could it not be? Did not the life force of a man extend itself to that of a woman's? I'm not perplexed. I recognize an amoeba lives. Likewise, I realize zygotic life force. Falsification analysis of Roe v. Wade 410 U.S. 113 yields no flaw in constitutional logic, but exposes its lien on zygotic life force as persona non grata by rejecting argument that the fetus is a person within the language and meaning of the 14th Amendment. If this suggestion of personhood is established, the appellant's case, of course, collapses, for the fetus's right to live would then be guaranteed specifically by the amendment. That's at page 157. Now, this is just a comment I need to make here. When I say that falsification analysis yields no flaw in constitutional logic, what I'm basically saying there is the framework that they're building on, okay, is a purely semantic one, parsing the language of the Constitution with respect to personhood. They also used the Ninth Amendment to construct a privacy right that does not exist anywhere in the Constitution. So basically they're giving a plausible framework under the Constitution for their argument. That's all I'm saying. They're starting from that point. They're not addressing life. They're only addressing what a person is with respect to the 14th Amendment, okay? And then because the Constitution doesn't specifically say person, they then go to the Ninth Amendment and construct a privacy concern that women never had in this country since the Constitution was written. But yet, even though that's not there, they then grab that. That's an activist opinion. While passing the language of the Constitution saying that person isn't there, that person doesn't relate to the unborn is clear by language. So they get rid of that personhood issue that way. That's how they're dispositive. But then they choose to insert their own opinion, not based in law or the history of what right a woman had, to snuff out the life within her. So, the court determined, quote, the Constitution does not define person in so many words. Section 1 of the 14th Amendment contains 3 references to person. The first, defining citizens, speaks of, quote, persons born or naturalized in the United States. The word also appears in the Due Process Clause and in the Equal Protection Clause. Now, this whole section with respect to the opinion, basically, I don't really need to read this because it just goes by article and sections, and I concede to the fact that the Constitution really, when it talks about persons, they're talking about persons, adults. They're not talking about children either. They're talking about adults operating within our society and what rights they have pursuant to those amendments. I concede to that, and there's no need to really go down to the list of those. So I'm going to move on, and I say, equating life with personhood was not shown explicitly, though implicitly, when considering a state's compelling interest to protect life. Passing on question of life initiation, the court opined, with respect to the state's important and legitimate interest in potential life, the, quote, compelling point is at viability. This is because the fetus then presumably has the capability of meaningful life outside the mother's womb. Now, this is a stretch, okay? Now, if they said, listen, it's viability because the Constitution doesn't say you're a citizen until you're born, then that's more logically consistent. But then to extend it to the viability of a person, it is, I'll get into that right now. I construe, quote, meaningful life outside the mother's womb to imply personhood, since it was deemed non-attributable to the unborn, irrespective of viability. Do you agree? What is a, quote, meaningful life? Moreover, does not the viability of a fetus require medical technology to sustain it? What if medical technology is capable of sustaining development of zygotic life force to maturity? Can a zygote have a, quote, meaningful life outside the mother's womb? Given my definition and logical deduction, life is without self-realization, an objective and reasonable person pondering previous queries should see such definitions of a person to be a value judgment based on projected functionality. Extrapolation of court's arguments lead to the logical conclusion that a zygote is not protectable because it cannot reach maturity outside the mother's womb. Hence, a scientist's creation of an artificial womb capable of sustaining a zygote from fertilization to free aspirating infant could be protected crossing row, since it would attain, quote, viability and, quote, presumably has the capability of meaningful life outside the mother's womb. Currently, there are thousands of cryogenically suspended potential Homo sapiens sapiens, pre-zygotes, being argued pursuant property rights throughout these United States. Recently, the New York High Court issued a judgment terminating Maureen Cass's appeal for what she argued was, quote, her only chance for genetic motherhood, while Stephen Cass, quote, objected to the burdens of unwanted fatherhood on purely contractual construction of in vitro fertilization program, release guidelines of property rights of donors. This was Cass v. Cass, 9-8, New York, 5798. Said court in Cass adhered to Roe by denying personhood to zygote and refused to, quote, decide whether the pre-zygotes are entitled to, quote, special respect pursuant Davis v. Davis, 842 Southwest 2nd. In Davis, the Supreme Court of Tennessee said that they conclude that the pre-embryos are not, strictly speaking, either persons or property, but occupy an interim category that entitles them to special respect because of their potential for human life. Now, what does that mean? Zygotes are in some kind of scientific purgatory. I mean, listen, biology is a lot more finite than that. Okay? That Tennessee opinion, he wanted to say something, but he couldn't say it, so he got in the middle of it. See, that's where, we break down. Okay? That means absolutely nothing. It's more dictum than anything else, even though it was kind of like the crux of his opinion. In my opinion. Right? So I go on to say, are we sliding or on precipice? While I argue life independent of self-realization, I acknowledge a zygote as being a human life force distinguishable from life force of individual gametes. Excuse me. Let me say that again. While I argue life independent of self-realization, I acknowledge a zygote as being a human life force distinguishable from life force of individual gametes. Joining of haploids initiates an irreversible process toward, if not terminated, adulthood. Therefore, a zygote is indisputably the beginning of human life. That it is dependent on life support, I find no different than ensuing second trimester or an infant needing mother's milk, only immature. With respect to, quote, meaning, the Cass litigants exhibited it. Is it abnormal to feel loss when unable to conceive or lose an embryo by miscarriage, rather than feel disappointment as though it was a broken yoke intended to be over easy? Reaching an issue pursuant 9th Amendment via 14th conjunction is proper mechanism when the court's syllogism is purely opinion-based, when addressing rights maintained by the people that are not delineated in or cannot be reasonably construed by our Constitution. Ergo, any amendment to the Constitution for the United States which deems personhood would either affirm or reverse Roe v. Wade, notwithstanding establishment privacy right therein. So that's the paper. And, just a few comments to wrap this up. This Roe v. Wade is a very weak opinion. There's nothing in Judeo-Christian belief that says that women had a right to terminate their children. I mean, if they want to go back to the Spartans when exposure was practiced or things like that, that's also irrelevant. In Judeo-Christian based law, life is tantamount. It's protected. It is only the rejection of that. And that's why even the opinion itself can't stand pursuant to the 9th Amendment, because a woman or a man never had the right to kill the unborn. That's just the way it is. Now, before I read the abstract that ties all the art pieces together in the third theme, just let me say that I believe there's a difference between a love life and a sex life. If a woman wants to pursue a sex life for her own gratification, whether with the man or without, that's her choice. No one is taking that from her. but the cost is going to be high. A woman, by the time she realizes how much she lost, is considered old age by procreation biology. It's around 30 years old, so they have another 40 years to live and not be biologically productive. But a man, on the other hand, can have a child anytime he wants, given that the system is working properly. That's just a fact of nature. That's not anything that man created. That's something that nature created. Because intelligent life such as ours needs to be nursed from the minute of conception until at least 20 years old. And indeed, even though our founding fathers did not have the advanced science we have today, they used 21 years old to vote because they understand the maturity of people. It's obvious to them through the course of their endeavors, barring anyone that was intellectually impotent because of some psychological or mental defect. In any event, when you pursue a love life, you're looking for a partner. Sex is just the benefit of that. So if you decide for a love life, in my opinion, you'll be much happier, whether you are heterosexual or homosexual, because it's those bonds between the two persons, okay, that make life more valuable, not the act of sex that only lasts 20 minutes. And that's why a lot of relationships fail, because they're built on the physical and not on the psychological. The physical will always fail because it's a transient feeling. The psychological is a connection that will endure even through the harshest times. So I'd ask you to just think about that for a second. Now, before I go, I'm just going to read the poetic abstract that ties all the artworks together. This is called Primordial Tendency. And there's a grammatical code to it that I'm not going to divulge, but I'm sure that some people can figure it out. So this is called Primordial Tendency. Mutual pheromones format libidos. Sexual stimulants catalytic. Prelusion inodorant. Consensual caresses fan eros. Tactual engagements erotic. Amorous precipitant. Psychosensual heat pertuberates penis. Sanguimotor rush erect. Injector anticipant. Erotoschematic mucus wets venous. Nectaurus lube oleic. Vulval expectant. Vaginal engulfment spurs undulance. Penile proboscis peninsula. Titillation promotive. Clitoral ecstasy fuels vibrance. Electric node perpendicular. Clasp copulative. Perspired teats accompany aria. Worked paps contributory. Climax close. Orgasmic throes shudder labia. Concluding grips ejaculatory. Seminal dose. That's the end of what I'm going to present with respect to primordial tendency. I wrote that in 1998. It's still relevant to today. I hope that answers that gentleman's query. Not that he's going to see this video, but it's for you. It's for Kristen Gillibrand. It gives an example of the difference between an activist judge and a constructionist judge. and it wraps up the basic primordial tendency of life. So, until next time, think free and be free.